now like to turn the conference over to Mr. Ryan Segrist. Thank you. You may begin.
Good afternoon, everyone, and welcome to 2015's first Ethics Fundamentals series. We here at the IEG are very pleased that we are going to be having two of OGE's experts from the Ethics Law and Policy branch here at OGE. Seth Jaffe and Lee Francis are going to be talking to us about teaching, speaking, and writing and what related to official duties actually means. It's a very complex subject, and it's one of my favorite things to do training on, so I hope you're as excited as I am. Before we get started, though, I do have a few announcements. The first one is that OGE has recently issued a new advisory about the pay threshold changes and how that applies to our various ethics laws. Also, next week, we're excited because we're going to be offering an advanced practitioner series on how to construct training plans and how you can use those to help protect your agency better. We're also going to be offering at the end of January an OGE Form 450 massive open online course that's going to be 3 parts. It's going to have a lot of practical application. It's about that time of year, and we hope that this will be a timely and useful training for you. And finally, for your colleagues who may not have been able to participate with us today, just remember that these broadcasts are all archived on the YouTube and Google Plus pages, and you can also access all kinds of other training materials on the IEG page in Max. So with that, I'm going to turn it over to Seth and Lee, and let's get started.
Hello, everyone. I'm Lee Francis, an assistant counsel at the Office of Government Ethics, and with me is Seth Jaffe, the chief of the Ethics Law and Policy branch. Today we're going to be discussing 2635-807, which contains a prohibition on the receipt of compensation for certain teaching, speaking, or writing that an employee does in their private capacity, and a restriction on the reference to official position when an employee is engaged in one of those expressive activities. Today we're going to explain one of the more complex elements of the compensation prohibition. Specifically, we are going to go through the element of whether a proposed teaching, speaking, or writing would relate to an employee's official duties. And we're doing that because we found that this is the issue that ethics officials struggle with most. Click form. Next slide, please. Thank you. To start with, at the broadest level, I want to make clear that 2635-807 does not limit an individual's ability to teach or write in their personal capacity. It merely limits when employees can get paid for it. So you might ask, well, when is that? Well, that is when the activity takes place while they are an employee in the executive branch and the subject matter of the activity relates to their official duties. We will be discussing the related to official duties prong today, as I mentioned, but before we do, I want to briefly go through the history of the prohibition. And I find this important for 2 reasons. First, 3 of the definitions listed in the, quote, related to official duties regulation are derived directly from these older authorities. Second, I think it helps shed light on 807's purpose, which is always helpful when providing prospective advice on given situations. Could we click, please? Now, this prohibition on teaching, speaking, or writing is derived primarily from interpretations of President Johnson's executive order, which is 11222 and was signed back on May 8th of 1965. Specifically, it is referring to Section 202 of that order. Section 202, which was then codified at 5 CFR 735.203, prohibited 2 things. First, it prohibited all employees from both compensated and uncompensated writing that would be based on non-public information. Second, it prohibited certain presidential appointees covered by the executive order, in addition to the first prohibition, from receiving compensation if the subject matter of the writing was devoted substantially to the responsibilities, programs, or operations of the employee's agency. Now, the first prohibition should sound familiar because it is essentially now a part of the related to official duties definition at 807A2ID. And I probably should have asked you before, but it's probably helpful if you take a look at 807 right now. Otherwise, all these number and letters that I'm saying might not mean a whole lot. The second prohibition should also sound familiar because it is very similar to the current 807 prohibition at 807A2I E2.
For those of you who are need a copy of the Standard of Conduct to take a look at this, if you go to the page where you registered on Max, we have a link to the ECFR there so that you can help follow along, as well as a lot of other very useful handouts, advisory opinions, and that sort of thing.
Thank you, sir. So now we're moving on in the chronology of the teaching, speaking, and writing prohibition. So in 1977, there was a very important memorandum that the Office of Legal Counsel in the Department of Justice wrote for President Carter's White House counsel. In that memorandum, which only applied again to certain presidential appointees, quote, devoted substantially was given two possible constructions. First, a narrow one that only prohibited compensation when the article or book related to existing statutory responsibilities and programs of the agency. This potentially narrow construction would have meant less limitations on compensated speaking or writing by an individual. However, for presidential appointees, OLC rejected this interpretation. The second interpretation, the one that was accepted, prohibited compensation when the writing was devoted substantially to the, quote, general subject matter or sector of the economy or society with which the individual's agency is concerned. Of course, this broader interpretation meant more limitations on compensated speaking or writing by an official. Now, the real importance of this OLC opinion stems from OLC's rationale for adopting the broad interpretation, which again increased the scope of the prohibition for those presidential appointees. The rationale was based on 2 points. The first point held that the prohibition was meant to prevent employees from engaging in activities which might result in or create the appearance of using public office for private gain. This is a concern that applies to all employees, again, not merely senior appointees. The second point held that the prohibition was meant to preclude an employee from profiting from publication or is likely to be attractive to the public because it represented the views of a department official on a subject matter within the responsibilities of that department. For example, the Attorney General could not be paid for writing on antitrust or civil rights law, but could be paid for his views on legal education. This concern, of course, was unique to presidential appointees and is what merited adopting the broader interpretation, which thus increased the scope. And thus that rationale sheds light on and explains 807's broader prohibitions on political appointees, or what are called covered non-career employees in 807. So, as mentioned before, the OLC opinion is quite important, and it was subsequently adopted by OGE if you would like to look at 85X18. And it also gives us 3 parts of the related to official duties definition. To go back over again. First, the prohibition on all employees, including special government employees, when the teaching, speaking, or writing draws on non-public information. Second, a prohibition on all full-time employees, or as we refer to today, regular employees, which is the narrow construction of Section 202 of the Executive Order. And third, a prohibition on presidential employees, or, as we term them today, covered non-career employees, which is the broadest interpretation. The opinion also explains that the narrow interpretation, where it related to existing statutory responsibilities and programs of the agency, was appropriate for employees because it would allow employees who wish to engage in outside activities to do so in those instances in which the likelihood that official information or position will be misused is minimal. And that's again for the regular employees. Finally, as the last bit of background before I turn it over to Seth, OGE in the preamble to the final rule noted again that the compensation prohibition in 807 was included because of 2 principles in President Bush's Executive Order 12674 as amended by 12731. First, of course, public office is not to be used for private gain, and as I mentioned, employees shall endeavor to avoid actions creating even the appearance of using public office for private gain. With the history and purpose as a foundation, we turn to the rule as it stands today. And regarding the current rule, of course, Deogram 08006 is the best and most thorough treatment of this prohibition. It sets up 6 questions that ethics officials must ask and answer to properly analyze an 807 question. And those are, first, what category of employee is seeking compensation for teaching, speaking, or writing? Second, what is the teaching, speaking, or writing about? Third, when is the teaching, speaking, or writing performed, and when is the compensation received? Fourth, what is the type of payment or compensation? Fifth, who is offering the compensation and why? And sixth, what other ethics rules and considerations apply or come into play? Now, today, again, we're only taking a small subset of those questions. Specifically, we need only analyze the second question, what is the teaching, speaking, or writing about? And the fifth question, who is offering the compensation and why?
Just so I'm clear, so what you're saying, Lee, is that we're only going to talk about a subset of the questions that you do need to ask when you do this analysis. There's still other questions that you need to consider besides what we're talking about today.
That's exactly right. So, I mean, there's a lot involved in any analysis like this. We're simply taking a subset, which is these two questions that we find to be the most complicated, and trying to delve into them today. Otherwise, it might take a lot longer to go through everything. I just want to kind of move on by simply saying that, because we need to properly address these two questions, I must note that you also have to know the type of employee seeking advice. So for today, we're going to talk about those types of employees. And there are three main categories for purposes of 807. Each has very specific definitions, but generally, as I mentioned before, there are SGEs. Those are executive branch officers or employees who are retained to work temporarily for more than 130 days in any 365-day period. And again, those SGEs, or special government employees, are further broken down into two types: those who work fewer than 60 days and those who work more than 60 days. Just to provide a quick example, an SGE might be an expert from the private industry who's appointed to perform duties as a member of an advisory commission, a FACA committee, for a government agency that meets a few times a year. The second type are what we call regular employees, as I mentioned before, and those are essentially all executive branch employees who are not special government employees, as just described, nor covered non-career employees under 5 CFR 2636-303A, which I will define next, and nor are they employees appointed by the President to a full-time non-career position. Again, the most typical example of a regular employee is your simple GS 13 or 14 at an agency who's in the civil service. Finally, covered non-career employees. Now, a covered non-career employee has three component parts. First, it must be full-time political appointee who is above the pay of a GS 15. Typical examples of covered non-career employees are general counsels at any of your major agencies. An employee, again, who is a general counsel and who is a career employee would not apply, as one of those prongs is not satisfied. So those are the three categories that you must know when analyzing the question of whether an expressive activity will be related to an employee's official duties. To avoid confusion, though, I do want to mention there are also presidential appointees, but they are not included as a category for this element because the definition of related to official duties for presidential appointees is the exact same as the definition for covered non-career employees. Rather, that distinction is only important for the other questions I recited from diagram 08006. I will now turn you over to Seth, who is the true expert on this subject. Seth?
Thank you, Lee. My name is Seth Jaffe. I'm the chief of the Ethics Law and Policy Branch at OGE. And Lee mentioned the 807 prohibition on many occasions. And 807 it does not prohibit any teaching, speaking, or writing per se. What it does is it prohibits the situations in which an employee can accept compensation for teaching, speaking, and writing when it relates to their official duties. And that's why we're talking about related to official duties today. So today I'll specifically address when writing is related to an employee's official duties. Also, as Lee mentioned, this issue only implicates 2 of the 6 questions you will want to answer when an employee comes to you asking whether she can get paid for an outside writing. Now, there are 7 ways in which a book or other outside writing may be related to the official duties of an employee, and these can be divided into 2 main classifications. First, a book may be related to an employee's official duties based on its subject matter. That seems pretty obvious. But less intuitively, a book may also be considered related to an employee's official duties based on who is providing the compensation and why. Because the subject matter of the book is a common issue you will be asked to analyze, let's summarize this first, and later we'll go back and go over it in more detail. So if you look at the slide that's on the screen now, it says, what is the speaking or writing about? And this is one way in which, of course, the writing can be related to the employee's official duties. And there are many ways under this prong that it can be related. First, if the writing actually was undertaken as part of the employee's official duties. So if that employee writes a report as part of their job and then tries to go outside and sell it to a publisher and get paid for it, that would be prohibited under this prong. Next, if the writing draws substantially on non-public information. In addition, if the writing deals in significant part with any of the three following prongs. One, matters to which the employee has been assigned within the last year. Two, if it deals in significant part with an ongoing or announced policy, program, or operation of the agency. And finally, if it deals in significant part with the general subject matter area or economic sector primarily affected by the agency. Now, the prong that's probably the most important and the one that you'll have to deal with a lot and struggle with sometimes is the agency policy, program, or operation prong. And this is a very common issue that you'll have to confront, so we're going to go into a much deeper dive into that in a minute. Now, the book may also be considered related to an employee's official duties based on who is providing the compensation and why. And this is regardless of its subject matter. And that's important to consider. A book may be related, or an outside writing may be related to an employee's official duties regardless of its topic. So one provision in 807 deals with the possibility that the public may question the integrity of a government official who is being compensated for writing a book based upon who made the offer. So if the invitation or the offer for compensation was extended by a person or an entity who may be substantially affected by the performance or non-performance of the employee's duties, then the book can be related to the employee's duties. So in other words, this is a complicated way of saying that you can't accept, an employee can't accept payment for writing a book from a bad prohibited source. And that's, again, regardless of the subject matter. So, for example, if the Secretary of Energy wrote a book for compensation on stamp collecting, and that book was to be published by ExxonMobil, and he was to be paid by ExxonMobil. Now, stamp collecting is a topic that's not related to the official's duties in this example, but this book on stamp collecting would be related to his official duties because of who made the offer. Now, a second provision deals with the possibility that the integrity of a government official writing a book may be questioned based upon why the offer to write the book was made. So if the circumstances indicate that the invitation to write the book was extended to the employee primarily because of his official position rather than because of his expertise in the subject. Now, we all know that an employee's government position is almost always a contributing factor to the reason they're being offered compensation for an outside writing. But their position, their official position, must be the primary factor before this provision would bar receipt of compensation. So, for example, how would you determine this? One, if an employee, let's take the last example, was to write a book on stamp collecting, but this employee had no demonstrated interest or experience or expertise in the area of stamp collecting, then maybe they were offered it because of their official position. Alternatively, sometimes offers are explicitly made because of the employee's official position. For example, a publisher might send a form letter out to all cabinet officials offering to publish their autobiography because they're a member of the president's cabinet. However, in practice, it's unlikely that either of these two provisions will provide the sole basis for telling an employee she may not receive compensation for writing a book. In the absence of an express offer because of official position, if this is the primary or sole reason you're saying to an employee who comes to you they can't get paid for writing a book, you might want to consult with OGE. Although no employee may accept compensation for writing that is related to their official duties, what is considered related to official duties varies depending on the type of employee involved. And Lee went over the different types of employees earlier, so I won't do that now. But this is a very important point. The rules that apply to the employee sitting in the chair in front of you who asked you this question will be different depending on who's sitting in that chair. The higher the level of the employee, the more concerned we are that the employee is using public office potentially for private gain. And as a result, the higher the level of the employee, the broader the definition of related to, and the broader the prohibition on the ability of the employee to get paid for outside writing. As a result, the definition of related to official duties is the most narrow, in other words, the least restrictive, for SGEs who serve or are expected to serve less than 60 days in any 365-day period. So on the slide in front of you, here are the ways in which an outside writing can be related to the official duties of an SGE serving less than 60 days. The first one is basically the bad prohibited source limitation that we just discussed, if the invitation is from a person affected by the performance or non-performance of the employee's duties. So that's the stamp collecting example with the Secretary of Energy. Next, if the invitation is because of official position. And again, we just discussed this a minute ago. In addition, as I mentioned earlier, if the writing was initially part of the employee's official duties. So if you have an SGE serving less than 60 days and they want to write an outside book or chapter to a book that was initially undertaken because of their official duties, they couldn't do that as a violation of 807. I'd also like to note that for regular employees and covered non-career, trying to get paid for writing that they undertook and that was undertaken as part of their official duties by an outside source might also be criminal violation under 18 U.S.C. 209, supplementation of salary, but SGEs are exempt from 209. Now, in addition, this SGE serving less than 60 days can't write and get paid for a book that draws substantially on non-public information. So what's non-public information? Non-public information is defined at 703B in the Standards of Conduct, and it says that it's this information that is not subject to FOIA or is explicitly protected from disclosure by a statute, maybe it's classified, or by an executive order or regulation. In addition, it can be non-public information if the agency has designated that this information is confidential. And also, if this information is not available and not authorized to be made available, then it may be non-public information. Now, very often I've received calls from agencies who present a similar type of fact pattern to me, and they're prepared to tell their official that they can't write and get paid for this. Very often there's an employee at an agency who, because he or she works there, they know the way the office works, they know the lingo or the phraseology of terms in the office, they know the routing of work. There's other information that is not otherwise known by the public that they only know by way of working at the agency. And the official will say, well, therefore, we want to tell them they can't write this book and get paid for it. And what I always say is, unless you can point to a particular statute that prohibits the release of this type of information, or an executive order, or a regulation, or a written policy at the agency that says this can't be released, if it's more, well, they learned information they wouldn't otherwise know and the public would not otherwise know and we wouldn't otherwise release because we don't tell people about how work is routed in our office. But that general concern that this person is including information that is not otherwise known, but you can't hang your hat on a particular statute, regulation, or executive order that prohibits its release, generally at that point, the advice I give is the person can probably write this book and get paid for it unless there's some other specific provision of 807 that would be violated. Now finally, if the book deals in significant part with party matters to which the SGE serving less than 60 days has been assigned within the last year, that's another way in which the writing can be related to this type of employee's official duties. So for example, if there's an expert consultant who works with the Department of Justice, and this consultant is called in to work on a particular prosecution, this SGE serving less than 60 days can't give a lecture and get paid for that lecture that specifically discusses this particular case that he worked on if that was within the last year. So these are the core restrictions that I just reviewed that all employees are subject to. But now let's start discussing the additional ways writing can be related to official duties for other employees. Now, the definition of related to official duties is identical for SGEs serving less than 60 days and for SGEs who serve more than 60 days in any 365-day period, except that SGEs serving more than 60 days also cannot get paid for writing that deals in significant part with matters, not just party matters, but all matters, to which they have been assigned within the last year.
So what you're saying is, Seth, it sounds like if you're serving more than 60 days, then we're going to be a little bit more worried that people are going to be using public office for private gain, and so we've expanded the number of government matters that they could be working on that this definition would then capture. Is that right?
That's right, Ryan. So basically, the rest of the presentation today will be ratcheting up the breadth of the definition of related to and ratcheting up, therefore, the limitations on what these employees can write or speak or teach about and get paid for. So for example, let's say we have an FDA FACA committee, SGE, and this FACA committee SGE is serving less than 60 days on a committee. And this committee is studying the appropriate warning labels for cigarettes. This SGE can get paid to write a chapter in a book concerning recommendations she made to the committee within the past year concerning general regulations of the tobacco industry. Because this is a particular matter, and it's not a party matter. However, if this very same employee served more than 60 days, she could not write this chapter and get paid to do so because her work on general regulations of the tobacco industry is a matter to which she's been assigned in the last year. Of course, I'd also like to point out that this assumes that she did not rely substantially on any non-public information that she learned while on this committee. So here are the core restrictions that all employees are subject to, as well as the additional way that writing can be related to official duties for SGEs who serve more than 60 days. Now, the definition of related to official duties for regular employees adds one very significant way in which the writing can be related to their official duties. Again, we're ratcheting up the ways in which the writing or teaching or speaking can be related to their official duties, and therefore ratcheting up the limitation on what they can get paid for. Specifically, personal writing by a regular employee will be related to their official duties if it deals in significant part with an ongoing or announced policy, program, or operation of the agency. So here are the core restrictions that all employees are subject to, as well as the restrictions for SGEs, for all SGEs, and the restrictions for all regular employees. The additional restriction prohibits, as I said, a regular employee from getting paid to write a book that deals in significant part with an ongoing or announced policy, program, or operation of the agency. Now, this issue and this prong of the related to test is an issue that comes up very often. I get many calls about this, and it's an issue that agency ethics officials often struggle with. So this is the issue that we're going to dive into in a little bit more depth. And as you see on your screen here, these are a list of resources for you to use that provide analyses of when an outside teaching, speaking, or writing activity might deal in significant part with an ongoing or announced policy, program, or operation of an agency.
And just to remind everyone, you can access these slides Yeah, there's an awful lot of really good resources that are on just this one slide, let alone all of them, but you can access these slides where you registered for the course. So if you want to use this later on as a resource, you can definitely download those slides and be able to find all the examples and stuff like that.
Thank you. So before I go into a little bit more detail about these resources, I just want to note a couple of things. First, in order for the writing to be related to the employee's official duties, it has to deal in significant part with an ongoing announced program, policy, or operation of the agency. It can't just deal in insignificant part or incidental or incidentally deal with it. In addition, it has to be an announced or ongoing policy, program, or operation. So an operation or policy or program of the agency that is no longer in existence is not ongoing. In addition, the word announced here is a forward-looking word, meaning that a program that was announced 30 years ago and is no longer ongoing is not subject to this prong, but it really refers to a policy or program that is announced by the agency but maybe hasn't started yet. But if it's announced looking forward, then it will be brought into this definition. So for example, if a NASA employee, a current NASA employee, wanted to write a book and get paid, and the book concerned the space shuttle program at NASA, well, that employee could get paid to write such a book because the space shuttle program is no longer an ongoing program. Now, for the purposes of the standards of conduct, agency programs or operations refer to any program or function carried out or performed by an agency, whether pursuant to statute, executive order, or regulation. And we say that at Section 102D of the Standards of Conduct. However, OGE has interpreted this to mean that employees may not receive compensation for writing about substantive core programs and operations of the agency that fulfill the agency's mission. Therefore, agency programs or operations may not include work that agencies perform that is not related to an agency's core mission. Examples of such work include responding to Freedom of Information Act requests or dealing with personnel disputes. But I would note, if you had your FOIA attorney come to you and ask if he or she could write a book about FOIA, then it's possible that that would be an ongoing announced policy, program, or operation of the agency for that employee. And it also might be the case that it's a matter to which the employee has been assigned in the last year and wouldn't be able to write about and get paid for. Although an employee generally may not get paid to write a book dealing in significant part with an ongoing policy, program, or operation of their agency, a regular employee, or an SGE, may receive compensation for writings discussing a general area of expertise that does not inherently implicate agency programs. So applying this general principle, a regular employee who works at NASA may receive compensation for writing a textbook on the general subject of aeronautics because the topic of aeronautics is not inherently an agency program or operation. However, if the book specifically focuses on NASA's Mars program, the employee could not accept compensation for writing because it would deal in significant part with an ongoing or announced policy, program, or operation of the employee's agency. In addition, as I mentioned earlier, in order for the book to be within the agency programs category of prohibitions, the writing must deal in significant part with agency policies, programs, or operations. Therefore, the NASA employee, in this example, could receive compensation for writing a book on aeronautics containing a single chapter discussing aspects of the Mars program. That's because one chapter of a larger book may not deal in significant part with the ongoing Mars program at NASA. And of course, this is the case provided the information described in that chapter is already available to the public and is not non-public information. So getting back to the slide on the screen in front of you, I want to talk about the last bullet point there. And you'll see that there's a reference to the Wolf versus Barnhart case. And that's a case from the 10th Circuit in 2006. And it involved the case in the situation of an administrative law judge at the Social Security Administration named Wolf. And Administrative Law Judge Wolf decided to write a handbook. And the handbook basically informed people how to present cases before a Social Security Administration ALJ. OGE, as well as the agency, believed that this handbook dealt in significant part with an ongoing announced policy, program, or operation of the Social Security Administration. ALJ Wolf did not agree. So he challenged that opinion, and that opinion is actually in both 01X7 and 01X10. And both of those opinions provide an excellent detailed analysis of determining when a writing might be related to an employee's official duties. And ALJ Wolf challenged this. It ended up going to the 10th Circuit, and the 10th Circuit had two significant findings. One is that the 10th Circuit upheld the constitutionality of Section 807 on First Amendment grounds. And second, the court did an in-depth analysis agreeing with OGE's determination that the topic of the book related to the official duties of the employee because it dealt in significant part with an ongoing policy, program, or operation of the Social Security Administration. Now, in 01X10, we discussed some of the factors that are relevant. We mentioned that the adjudicatory process before ALJs inherently involves the workings of the Office of SSA in which ALJ Wolf worked. Also mentioned that the subject matter of the handbook was integral to the performance of the ALJ's job. It was also mentioned that the writing necessarily involved close examination of specific policies, programs, and operations of his agency. So moving on now to covered non-career employees. Now, the definition of related to official duties for covered non-career employees as one more very significant way in which outside writing can be related to an employee's official duties. Specifically, personal writing by a covered non-career employee can be related to their official duties if it deals in significant part with the general subject matter area, industry, or economic sector primarily affected by the programs and operations of the agency. So for example, let's say we have a Federal Reserve Board regular employee. This employee can get paid to write a textbook on macroeconomics because macroeconomics is not an ongoing policy, program, or operation of the agency. However, a covered non-career employee at the Federal Reserve Board cannot write this same textbook and get paid for it because it deals in significant part with the general subject matter area affected by the programs and operations of her agency. Here you can see just how broad the definition is and how significant the restriction can be for covered non-career employees. This is the result because we are particularly concerned that high-level employees may try to leverage their government position for their own personal gain by securing lucrative writing contracts. Now, I'd just like to take a minute to discuss a note to 807, and this note is at 807A2IE. And I want to talk about this for a second because this note, it can be a little confusing and it's often misunderstood. The note basically says that for other than a covered non-career employee, so now we're talking about regular employees and SGEs only, so regular employees and SGEs may get paid to teach, speak, or write on a subject matter within the employee's area of expertise based on their educational background, even if it deals generally with the subject matter within the agency's area of responsibility. So how does this work in practice? Well, one of the ways it works in practice is just the example that I just went over with the Federal Reserve Board member and the difference in what she could write about if she was a regular employee versus a covered non-career. Another example would be a National Labor Relations Board attorney and former professor wants to write a book about the history of the labor movement in the United States. If this attorney and former professor is a regular employee, she can write the book and get paid for it because it does not deal in significant part with an ongoing policy, program, or operation of the agency. But if she is a covered non-career employee, she may not get paid for writing this book while an employee at NLRB because the book deals with the general subject matter area affected by the programs and operations of the NLRB. The bottom line is that the note just tries to reiterate the point that regular employees are allowed to get paid for writing based on their expertise, even on a subject matter generally associated with their agency's practice area, so long as no other specific provisions of 807 would be violated. So, in conclusion, here are the core restrictions that all employees are subject to, and all SGEs, and regular employees, and finally, the restrictions that also apply to cover non-career employees when it comes to whether they can write and get paid for a book that relates to their official duties. And now for the most important slide of the day. If you have any questions, please ask your desk officer. So it's my understanding now that we're going to open this up when we can for people who have questions. Thank you.
That's right. Thank you guys very much. And Sheila, could we open it up for questions, please?
Absolutely. We will now begin the question and answer session. If you would like to ask a question, please press *1, unmute your phone, and record your name clearly. Your name is required to introduce your question. If you need to withdraw your question, press *2. Again, to ask a question, please press *1. It will take a few moments for the questions to come through. Please stand by. Again, as a reminder, please press *1 on your phone and record your name if you have a question. One moment, please. We do have a question from Troy Byers. Your line is open.
Hi, yeah, this has to do with the non-public information. You spoke about it when you were talking about SGEs. Does that very narrow take on non-public information, meaning something that is not releasable as opposed to just not in the public domain, applicable to all anybody who we're doing this analysis for?
Yes, so the definition of non-public information does not vary by the type of employee.
Okay, thanks. I just wanted to make sure. I always interpreted that a lot more broadly. Thank you.
We're showing no further questions at this time, but as a reminder, you can press *1 on your phone and record your name if you have a question. One moment, please. And we are still showing no further questions at this time.
Okay, let's go ahead and wrap this up for today. I want to take a moment to say thank you very much for joining us today, and especially thank you very much to Lee and Seth for offering their expertise to us on this very complex subject. Just one more reminder, join us next week on Thursday at noon for our advanced practitioner covering training plans, and I hope that you have a good day. This is Ryan Segrist signing off.
That concludes today's conference. Thank you for participating. You may